Welcome to Work Comp Talk. My name is Carmen, your host for today's podcast, and joining me as usual, Bilal Kasim, managing attorney at Pacific Workers, the lawyers for injured workers, who also happen to be the sponsors for this podcast. If you haven't yet subscribed, if you're new to our channel, make sure you subscribe so you can get first dibs when we download some new content. You get information, get the notification as well going so that you get notified on your phone and you don't miss out on this amazing content. This podcast is created to educate the injured workers all over California. We talk about a ton of topics relating to work, to workers' comp, to just in general things that affect anyone who's working or anyone who knows someone who got injured at work. There's just a lot of information to be provided. Speaking about work, today's podcast is going to be essentially work payments, wages, just employment issues that happen all the time. There's just no way to put it out there. It's simple as, people getting paid unfairly, people getting treated unfairly. There's just so much to dive into, and who best than Bilal to explain. Now, you might be asking yourself, why are we talking about employment laws in workers' comp? There's a lot of interconnection. You guys see a lot of this stuff, and people don't even know that they have these laws available to them. They don't even know they're getting jacked by their employer.
Yeah, there's a lot of overlap between the two. I think when we take on a lot of workers' comp cases, we also find a lot of other bigger issues too. Mm-hmm. Usually it's kind of, what's the term? It's like the tip of the iceberg, you know? When someone gets hurt at work, there's often there's much more to it than just that.
So tell me, what is one of the common ones you would see when someone gets injured, they come to the firm and you're handling the workers' comp? What's the common one you see on top?
Typically, we would refer to these issues as wage and hour issues. Mm-hmm. So in California, there are certain wage and hour laws, and those govern how you're paid, when you're paid, the type of payment you receive, meal periods, rest periods, overtime, and those things are all fairly common. Usually one of the most common examples is wage and hour violation for non-payment of overtime wages, where someone is paid a flat rate day in, day out for the hours they worked, regardless of the number of hours they worked. And so in California, there's particular laws which govern overtime, which say if you work more than X number of hours, you have to be paid 1.5 times, or if you work on holidays or things like that, it's double time. And so there's a lot of employers that don't actually follow these rules, and they'll pay their employees just the same amount regardless if they're working 20 hours or 70 hours. And so that's something we see commonly. Along with that, we see pay stub violations. So the labor code mandates that your pay stub as an employee has to have certain things on it. It has to tell the number of hours you worked, the rate at which your hours were worked. There's common things you'll see as a California employee for things like Medicare, Social Security, state disability insurance that are all line item deductions on your pay stub. That pay stub is supposed to be provided to you with every paycheck you receive. That alone, it's a $100 violation per pay stub. There's also attorney's fees that are attached to that if you hire an attorney to go after your employer for that. Meal periods and rest periods. If you are working a certain number of hours, you're entitled to rest breaks as well as a minimum of a half-hour lunch. And so you see a lot of these things come up in workers' comp cases because the employee is mistreated. And oftentimes these things kind of go hand in hand with a badly run business.
And it sucks. We might be talking about this and it might seem like logic, right? You're supposed to get You're supposed to get an essential paycheck with your pay stub. But unfortunately, a lot of people they overlook it. They don't even think about it. Your boss will tell you, hey, sorry, we couldn't get the pay stubs out and the computer jammed or anything. They come up with the stupidest excuses. Oftentimes it's occurring constantly and you kind of just let it go, And when you think about it, how do you even know what they're paying you for? How do you even know if you're getting paid the accurate things? When I was young, I still am, I would never, ever download my pay stub because it was kind of like, I would just get direct deposit.
It is what it is.
Yeah. Tell me why I found out that I was not getting paid holiday time when we were working holiday hours. I was not getting paid the correct amount. And then also the extra hours, like your overtime and stuff like that. I was not getting paid the correct wage for those. I had no idea Why? Because I wouldn't look at my pay stubs.
You don't know what you're not missing, you know? And I think most people just don't know what the law is, right? And
Exactly.
I think
That's it too.
you just don't understand. And so if you maybe go and you research something on the internet, or like your friend's like, hey, do you get paid overtime? And when you're talking about the fact that you're working 70 hours a week and you're like, I don't know. And so you go and you ask your boss, like, hey boss, do I get paid overtime? And your boss is like, no, you're not entitled to that. Like, what are you gonna do? You're gonna be like, okay, I guess, my boss said I don't get that, so I don't get that. Most people, I think, are just kind of ignorant to it.
Yeah.
But there's also a power dynamic as well. Maybe you have a job that's, you're getting paid good money, I'll bet illegally. Maybe you don't want to rock the boat because you're like, oh, well, shit. If I make this, if I complain, I'm going to lose this job. And then where else am I going to make, X dollars?
Correct.
Which is a problem. And I think also too, there's the component to it where, maybe it's a situation where it works till it doesn't. So maybe you actually like the setup. Maybe you like the fact that you get paid in cash and not on a check. So, you don't pay taxes and things like that. And so, of course,
until you get caught by the IRS and you're screwed with a massive bill.
And then to hell with your boss. Then you're going to sue him for wage and hour violations, right? No, but that comes up a lot too. And, I think also in the context of a lot of employers that we see this happening with, it's with migrant workers, it's with workers who aren't necessarily legally allowed to work in the United States. And the law, both case law and statutes, pretty clear about the fact that it doesn't matter whether or not you're legally allowed to work here in the United States. Once an employer employs you as an employee, they have to treat you just like everyone else. You're still entitled to the same wage and hour benefits and workers' comp benefits that a legally authorized employee in the United States would be entitled to.
Now, I know a lot of people get injured at work. And I want to say that it happens a lot because people are working in a fast-paced industry, or they're overloaded with a ton of duties. They don't take their breaks. Mm-hmm. They don't take the proper lunchtime. Let's talk about that, the importance and the rules. What are the laws when it comes to breaks? Because again, people don't know that they're entitled to a break after X amount of hours.
Yeah, so this was a huge issue actually back when I started practicing law over a decade ago. It was really undecided. Like, to what extent does an employer need to go out of their way to make sure that you clock out for lunch, that you take your mandated breaks within the certain amount of mandated time that you're allowed to, and whose responsibility ultimately is it? And there was a case called Brinker, and it was a California Supreme Court case. I can't remember exactly when it was. I'm sorry, my hair is getting too gray. It's I want to say it was 2013 is when this case came out. I could be losing it, but I'm pretty sure that's when it came out. It was a long time ago. And that really addressed the question of what was the employer's responsibility. And essentially, it clarified the fact that the employer needs to give a reasonable opportunity.
Okay.
And so, sure, there's always going to be issues where an employee, doesn't want to clock out because they're like, oh, I'm in the middle of this project, or I'm on the phone with this client, or I'm doing X, Y, and Z, or you know what, I just don't want to even take a lunch because I want to make money.
Yeah.
And the employer just has to provide them a reasonable opportunity to do that. And so there's a variety of circumstances where an employer could be deemed not having done that. So like, let's say you work at a coffee shop and you're the only one working that day. And you're like, okay, well, I guess I need to close up shop, take my lunch. And your employer's like, no, don't close the shop. You need to stay there and work.
Yikes. What do you do?
Well, yeah, that would be an opportunity where, well, if you can't leave, but you need to leave and you can't close the shop, were you given a reasonable opportunity to take your lunch break? And the answer would be no in that circumstance. But there's obviously a bunch of gray areas. And typically, like the law is, we have our legislature who makes the rules, and then the courts and the lawyers which argue about the application of those rules. And so that's still getting fine-tuned, and it will continue to be that way over the years. But I think when you're talking about meal and rest periods, you really have to look at the circumstances and ask yourself, did my employer give me the opportunity? Really, did they? And if they did, and it was on me that I didn't take it, I think that's your own problem as an employee.
You're screwed.
Yeah, but you also have to be, mindful of it as an employer. As an employer, this is why there's a lot of pushback from the employers where like, you have to take your lunch, you have to clock out, and they're like on you, and they'll actually, I've heard of people getting terminated because they failed to clock out for lunch on time, and stuff, because the employers don't want to get sued. They take this stuff very seriously in a lot of cases.
Because it's serious. It's serious violations and just a lot of money they would have to pay if shit hit the roof.
Yeah, and it's always like, as an employer, I used to do employment law defense a long time ago. Ooh. It's very hard to prove one way or another. It becomes a he said, she said battle. So as an employer, if you're very soft with your employees about clocking out for lunch and taking breaks, and you have a great relationship with your employee, but then later on they turn around, they say, hey, you know what? I was never given lunch periods. I was never given meal periods or rest periods. I was never afforded that opportunity. And as an employer, you were soft and you didn't ever document it. You didn't write them up for it. You didn't fire them for it. And they're just the whole time going on about this. Now, as an employer, you have to defend yourself in court in front of a jury about whether or not you gave them the opportunity from lunch break, even though you know damn well you did.
Yeah.
But as an employee, you know, if they're not giving you the lunch breaks and the rest breaks, make sure you're documenting it.
Yep, for sure. Yeah. That's a very important. You touched on a subject earlier, which also I want to kind of dive a little into. The fact that a lot of these migrant workers or people that are working, you know, with fake social securities or whatever the case may be, it's people that feel that because I am not legal here in the United States, I need to keep my mouth shut. Otherwise, one, I'll lose my job, or two, I don't have the same rights. That's not the case. Once you're working for any employer here in California or in the United States for the most part, you're entitled to the same benefits, to the same rules as any other person with papers or that is legally able to work in the United States.
Absolutely. Absolutely. There's no differentiation. And the reason for that is there's a huge burden placed on the employer that it's the employer's responsibility to vet whether or not someone's lawfully allowed to work in the United States. To the extent that the person is using a fake social security number, well, they're still paying taxes. They're still, you know, contributing to Medicare, Social Security, state disability. Granted, it's not their Social Security number, but it's not like the money's going off into the abyss. You know, the employer's still paying payroll tax and all that other stuff as they normally would. And so you can't just say, well, you were using a fake Social Security number, so you don't get anything. Of course, someone who doesn't have a Social Security number and the employer knows they don't have a Social Security number, that they're not lawfully allowed to work here, they don't have a work permit or anything else, that's on the employer because you knew damn well what you were doing, right? You thought that you were going to hire this person. You know they weren't legally allowed to work here, so you had the power over them to abuse them, pay less than market rate, to not give them meal periods, not pay them overtime. And now you want to be upset about the fact that they're suing you for, you know, wage and hour time violations or, you know, they're pursuing a work comp case because they got hurt and you're trying to say they weren't an employee. You know, we see that a lot, unfortunately, and the employer is absolutely at fault for that. Of course, for the person who's engaging in fraud or unlawful conduct, you know, the fact that they are entitled to those benefits, whether it's workers' comp or wage and hour stuff, does not absolve them of the fact that they may face legal repercussions if and when they're ever caught. But that would be an immigration issue. It wouldn't be something that would typically come up in a workers' comp case or an employment law case.
Good to know.
Yeah, in fact, it's illegal to threaten criminal prosecution in a civil case to try and have an advantageous position. Ooh. So, you know, if you're going through a civil case and, you know, the civil attorney for the employer says, you know what, tell your client they're going to drop their case or I'm going to report them to IMS, they're going to be criminally prosecuted, blah, 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 blah. That would be unethical and unlawful as well.
That would definitely get people in trouble. So we talked about the wage issues, you know, people not getting paid correctly. Now let's talk about misclassifications. And I know we've had conversations about this. We even had an entire podcast regarding misclassifications. This is also an employment law. This is also something that you guys see a lot.
Yep.
Let's dive into a little bit of that section as well. And we will be linking that podcast so you guys can dive into it deeper for the misclassifications.
So this comes up a lot, especially in construction.
Okay.
Probably more so than any other industry.
What about nursing and stuff like that? Because you know how like some nurses, travel nurses and stuff like that?
Yes and no. I mean, I think the biggest issue that comes up sometimes for contract nursing, as well as what we'd consider professional employment organizations, is who is actually the employer. So there's two types of employers. There's general employers and there's special employers. And a good example of this could be someone who works for a staffing agency who's placed at a facility to work. So you could have a nurse. Yeah, Tesla. Or you could have, a nurse that works on contract for an organization that places that nurse in a particular hospital for a period of time or something like that. And so in those cases, you just have to be mindful of who's paying the checks, who's providing benefits, and that's generally the employer. But that's not really an issue of whether or not there's an employee or employer relationship, because they are receiving proper paychecks, deductions, and all that stuff. The employer issue or the misclassification issue comes up when someone's not treated as an employee as they should be. So someone who's paid flat rate, someone who's not given benefits, time off, someone who's not afforded meal and rest periods. And when you go and you sue them for wage and hour violations, or if they get hurt, a workers' comp case, the employer turns around and says, no, you were not an employee. And that comes up a lot. I think I said particularly in construction, where you have someone who is a laborer and the type of work they're doing is maybe infrequent or based on the type of projects that are available and stuff. And so the employer doesn't want to deal with the normal employee issues.
Right. Getting workers' comp, having to pay. Yeah.
And so you see it a lot when they certify their work comp status for purposes of maintaining their contractor's license. And you can look this up on the Contractor State Licensing Board if you are currently in this situation. Your employer has to say whether or not they have workers' comp, and they can declare that they're exempt because they don't have any employees.
Correct.
And you'll see this where it's a company with like 50 laborers doing construction work, and the employer's like, nah, we don't have any employees, even though they're doing everything an employee would do, right?
Right. And they even have the employees driving their vehicles.
Yep,
with
wearing
the company
their
logo.
company T-shirts, working on company jobs, getting paid, company wages on company checks.
But they're not part of the company.
No, but they're not part of the company. They're their own thing out there. They don't get anything. And we see that a lot. And it's something we have to fight over in workers' comp. It's something you certainly see in employment law. You can do a couple of different cases for that. You can do class actions. So if you have enough people that are similarly situated, meaning mistreated in the same way, in the same status, you can allege that they are a class of people. And that because they have such similar issues, the case should be litigated as one big case rather than individually, just because there's so much similarity and so much overlap. It wouldn't be judicially efficient to try every case differently. And so that's how you see class actions in that case. There's also something called the Private Attorneys General Act in California, which I haven't done too many of these cases, but they're out there. And usually you have to file certain paperwork with the DWC and you have to notify them. But ultimately, you kind of, I guess, get deputized in a way to fight the case on behalf of the state of California.
Interesting.
And so you take essentially a cut of the attorney's fees, and some of it goes to the state as well. But you're basically acting as an extension of the state to sue an employer for misclassification issues.
That's insane. And you said you guys see this a lot when it comes to some of the clients you guys take in for a work injury. They come in for a work injury, and then it's like opening up a can of worms. It's like, wait, how about this and this? What happens when you get a client that's in that situation? Do you guys handle the work employment law situation, or does that get referred out? What's the best avenue to go about that?
I used to do a lot of these cases just because it's where I started my practice from and I know it very well. I don't do many of them anymore. We do work with great referral partners and firms that we trust and do business with quite frequently, where even though they're a separate firm, we work together on the case. It's a separate law office, but it's like we're friends. We talk regularly. We work together. We socialize. So it's like they're an extension of us. And so we'll handle the workers' comp case hand in hand with them.
Nice. That's good to know. When someone does not have a work injury and is listening to this podcast, or if someone feels the need that they need to share this information because you feel like someone's getting, mistreated when it comes to the employment law, is there options for them to take? Should they just go straight to an attorney? Can they go to the, I don't know.
Some people can go to the labor commissioner. It's a way of doing things. Of course, depends on what your objective is. The labor commissioner is a public entity. It's not, a private attorney who's going to represent you and really ensure they're fighting for you in the same way that you would get representation. Labor commissioner is more, entity where you would go to correct your employer's actions and kind of fix the problem. The employment attorney is going to seek damages and really try and work up the case for the value. Of course, even if we're not employment lawyers, we're happy to look at a case. So people come to us all the time with questions, whether it's family law, immigration law. A lot of these cases pop up, and I know enough about it. Our team knows enough about it where we can guide people through and get them with the right attorney that can actually help them with whatever their issue is.
That's good to know. So is there anything else we need to touch on as far as like employment laws that you see firsthand when you take in some of these work cases?
Yeah, I mean, if you have any question about what's going on, don't wait. There's statute of limitations to pretty much most cases, shy of murder, I think, or some other, serious criminal charges. I think those are exempt from time limitations. But, wage and hour violations and pay stub violations, all those things definitely do have statutes associated with them. So, I guess word of caution would be if you think your employer is doing something shady or wrong, get a consultation with an attorney. Worst case they tell you is no, it looks like everything's good to go. Best case they tell you, hey, you're in some serious trouble and your employer's really messing things up and we should take legal action.
Yeah. I'm going to just throw it out there. I know as a workers' comp attorney or law firm, workers' comp attorneys get paid on a contingency fee. That means if you have a work case and you settle, then the attorney gets a portion of that settlement, no more than 15% here in California. But what about employment law? Do they get paid?
They do. So employment law is a different beast. Most civil attorneys in employment law cases and personal injury cases will take anywhere from 30, usually at 33's minimum percent, all the way up to 40 or 50% plus costs. Workers' comp, the cases aren't as expensive for us as lawyers to work. And so generally we don't pass on any costs to our clients. But in employment law, it's a different animal. There's a lot of discovery. There's sometimes a lot of depositions, document production, copying, filing fees, expert witness fees, all the stuff that is a cost ultimately gets passed on to the client.
I'm assuming at some point, PI, private investigators, you have to kind of go spy on your employer and see kind of the damages.
I guess in an employment law case, like let's say, there's several individuals that were misclassified. Most likely all those individuals are going to have their depositions taken. There's probably going to be several employer representatives that have their depositions taken. If it's a wrongful termination case, you might have to hire an expert witness who's an economist to talk about your future lost wages and economic damages.
Oof.
And those get expensive. If you want to hire, for example, I know this so well in the work comp and personal injury space, let's say a doctor to come testify at trial for a day is an expert cost that can cost me as an attorney upwards of $5,000 for one day. And the costs get passed on to the client and ultimately taken out of the settlement. Because sometimes as an attorney, you can have $100,000 plus in costs. And so if your attorney fee, let's say, is $75,000 on a case and your costs are $100,000, it makes no sense to take the case. So the case, generally you'll see the attorney deduct the costs, then they'll deduct, their attorney fee and then whatever's left over. In some cases, you can get attorney's fees and costs depending on the type of case. It's built in by law, by statute, so that it's not a deduction that the client eats. But every case is different. It depends on what case you're talking about, what your cause of action is.
Interesting. That's good to know. Well, there is a lot of information for this. If you want to dive into it online, where can they visit to get more employment laws? Should they just hop on the California State Gov?
Yeah, Google's a good place to start. But that being said, make sure you understand the resource that you're looking at. Make sure that you're actually reading the right thing and you're understanding. There's a lot of information out there that's not necessarily accurate.
Right.
But you can just Google a lot and get a pretty good understanding of things generally. I would say more specifically, don't decide to take any legal action unless you've talked to an attorney, perhaps. But
heck yeah.
At least get an idea. I think a lot of the state websites have material on overtime, rest periods, meal periods, and just the basic nuts and bolts of things that you should be paying attention to.
That's also on your employee handbook when you get hired.
Yes, if they have an employee handbook.
If they have one, it should be stated there, which you can hold it against them, obviously.
Yep.
But we hope that's not the case for you. And if it is, seek legal action. Know your rights. We hope that this information we just shared allowed you to understand kind of some of the things that are common, unfortunately, with employment law. And yeah, I'm excited to share this type of information. It's a little bit different than workers' comp, but it marries into workers' comp. It happens, and you guys see it often. So don't be quiet about it, because if it's happening to you, I bet you anything is happening to other people, and that sucks.
Yeah, there's a lot of overlap all the time.
Definitely. Well, thank you guys for joining us at one more episode here of Work Comp Talk. We'll join you on the next episode. Please subscribe on your favorite podcast channel. We're super excited because we finally got over 10,000 downloads. Thank you to everyone who's supporting the podcast. We hope you enjoy this and share it with others. We'll catch you guys on next week's episode.